In this video, you'll learn whether you can sue your employer instead of proceeding with the work comp case. If this is your first time to my channel, my name is Domenic Celeste, the virtual accident attorney. I'm based in Palm Beach County, Florida, and I represent those injured on the job in workers' compensation and due to the fall of another in personal injury. This channel is all about answering your questions and giving you tips relating to Florida workers' compensation and personal injury law. Now before we get started, I have to show you this disclaimer, so just hold tight. And with that out of the way, let's get into the video. If you get hurt at work, can you sue your employer instead of proceeding under work comp in Florida? Sure you can. You can pretty much sue anyone for anything. However, the bigger and more important question is, will you be successful? In Florida, chances are if you get hurt at work, you will not be successful in suing your employer for your work-related injury. But why is that? Because in almost all instances, your employer is immune from being sued for your work-related injury. So let's go over why and get into the rare circumstances that may allow you to sue your employer for your work-related injury. Way back when, as a compromise, the Florida workers' compensation system was created, which in exchange for losing the right to sue employers, injured workers gained the right to medical care and a percentage of lost wages paid for and provided by the workers' compensation carrier if they met certain criteria. This was seen as a mutually beneficial compromise to both injured workers and employers at the time, although as time has progressed, the law has swayed to be more in the favor of employers and against injured workers. The compromise was that injured workers' own negligence or fault was removed from the equation, which is probably one of the most litigated issues in a personal injury case. Further, instead of trying to figure out how they were going to pay for medical care or how they were going to survive while out of work, injured workers were given medical care and a percentage of lost wages paid for and provided by the work comp carrier. So far so good, right? Well, at first glance it seems that the employers were getting the short end of the stick here, but in reality it was the injured workers who were truly getting the short end of the stick. You see, in work comp there are only two types of damages or benefits: medical care and lost wages. However, medical care is paid at pennies on the dollar, and lost wages is typically paid at around 2/3 of your average weekly wage. This is already saving the employer and their insurance carrier tons of money. Further, unlike in a personal injury case, there are no damages for pain and suffering, loss of enjoyment of life, or punitive damages, which is even more in savings. So now you see, even though employers and their insurance carriers are paying during the pendency of a case, they are paying way less than they otherwise would before the system was created. Also, even though fault isn't a consideration anymore, there are plenty of more reasons why the employer carrier will deny your case, which results sometimes in you getting nothing compared to comparative fault, which is where your recovery is reduced by your own percentage of fault. Now that you know a little of the history, now let's talk about the rare instances when you may be able to go back in the past and actually sue your employer outside of the work comp system, which is what we attorneys call cracking comp. The most common way to crack comp is if your employer failed to secure workers' compensation coverage when it was required to do so. In this situation, you could proceed with your case in circuit court, which is where personal injury cases are heard, rather than in work comp court. The benefit of this is you can sue your employer for damages that would otherwise be unavailable to you in a work comp case, like pain and suffering. You would also get to see your own doctors, however, you would have to pay for them yourself. Further, you get the massive benefit of your employer losing the ability to argue that the accident was occasioned by a co-employee, assumption of the risk, and most importantly, comparative negligence, which reduces your recovery by your own percentage of fault, which are its primary defenses in a typical personal injury case. So because of this, instead of arguing about fault like you would in a typical personal injury case, you just argue damages, or in other words, how much does your employer have to pay you for your work-related injuries. Another way to crack comp is if your employer claims that you were an employee. In this instance, if you're not an employee, then you don't qualify for work comp. Thus, you can proceed as if this was a personal injury case. If you do that, your employer will try and get what's called a summary judgment in the personal injury case, saying that you are an employee, which is the complete opposite of what they said in the work comp case, and they can't do that. Your employer can have it both ways. You're either an employee or you're not. Another way to crack comp is if your employer intentionally injures you, but this is almost impossible to prove because there usually isn't any documentary evidence in existence, which leaves only testimonial evidence, which is where people tell their side of the story. Here, your employer will bring every one of your coworkers to testify against you that the accident wasn't intentional. So now it's your word versus theirs. Another issue is that your employer's liability insurance, which is the type of insurance in play here, most likely doesn't cover intentional acts. So you'd be seeking compensation from your employer's pocket rather than its insurance, which is not easy to collect on. The last way to crack comp is if your employer engaged in conduct that it knew based on prior similar accidents or explicit warnings specifically identifying a known danger was virtually certain to result in injury or death to the employee, and the employee was not aware of the risk because the danger was not apparent, and the employer deliberately concealed or misrepresented the danger so as to prevent the employee from exercising informed judgment about whether to perform the work. Again, this will mostly be testimonial evidence, but there is a better chance as compared to showing an intentional act that there is documentary evidence that your employer had knowledge. Even if you may meet any of the criteria for the few ways to crack comp, most attorneys won't even try because it's extremely difficult and it costs a lot of time and money. Further, if you choose to go this route, you could be stuck with your choice, which means if you lose, nothing for either you or your attorney. So there you have it. Now you know how you can try to sue your employer and why it's almost impossible to do so when you're hurt at work. Make sure to subscribe and hit the notification bell because my next video will be explaining whether you should sue your employer if you could. So as you can see, Florida workers' compensation law can be really complex, but what can you do about it? Well, you can hire an attorney that's licensed to practice law in Florida and that handles workers' compensation cases, that represents real clients, goes to court, that knows what they're doing. And if you or someone you know were injured on the job or due to the fault of another, give me a call any time of the day or night. I have a 24/7, 365 receptionist, or you can go to my website to fill out an intake and schedule a free consultation. Or you know what? You can just text me, 561-935-3822. But that's it for this video. If you got value out of it or if you learned something, please hit that like and subscribe button. It really helps me out. If you have a question, let me know in the comments below and I'll try and answer it. Like and follow me on all my socials to stay updated. And if you want to learn more about me, my firm, Florida Work Comp, or personal injury law, just go to my website, virtualaccidentattorney.com. Alright, so that's it for now. Again, my name's Domenic Celeste, virtual accident attorney. Thanks for watching, and I'll see you in the next video.